So chapter 6, estates and interests. In this chapter, we're going to talk about the characteristics of an estate and land. We're going to learn what that term estate and land is. We're going to learn what an estate is. We're going to describe the characteristics of things called encumbrances, what encumbrances are. We're going to learn about liens, easements, encroachments as well. So an estate and land describes the amount and kind of interest that a person has in real property. But if you look on page 103, their definition says it describes the amount and kind of ownership interest. But that's only because this particular chapter is talking about ownership estates. In chapter 12, we're going to talk about the 4 types of leasehold estates, which are less than freehold. This chapter, we're going to talk about the 3 types of freehold estates, which is the category of ownership. So the estate and land, to make that definition more accurate, we're going to, well, I'll show you on the next slide. Let me just first go over it here. We're going to cross out the word ownership and just highlight that sentence. But an estate and land describes the amount and kind of interest that a person has in real property. And there are 2 categories of estates and land. They could either be freehold, that is the category of ownership type of estates. And there's 3 types of freehold estates, which we're going to go over in this chapter. And then if it's not freehold, free to own forever or a lifetime, it'll be less than freehold, which is basically a leasehold estate. And the leasehold estates and leasing, we're going to go over those 4 types of leasehold estates in chapter 12. So do this highlight on page 103 and cross out the word ownership just to get the most correct definition of an estate and land. What is an estate and land? It's the amount and kind of interest that a person has in real property. This particular chapter is going to be talking about that ownership category, which is the freehold estates. So after you highlighted this and cross that out, turn to page 104 and highlight freehold estates and then write ownership category, 3 types. And then leasehold estates, 4 types. Chapter 12, page 226 is where we're going to go over those 4 types of leasehold estates in a much later chapter. But I'll mention them in this chapter so you know what those 4 types of estates are, but I'm not going to go over them with any specificity. And let me know when you got that so I can move along. Everybody get that yet or no?
I got it.
Okay. There are 3 types of freehold estates: fee simple, fee determinable, and a life estate, which we will go over in this chapter. So let's just write the number 3 in front of freehold estates. Let's highlight freehold estates and then highlight the 3 freehold: fee simple, fee determinable, and a life estate. We will be going over them with specificity in a moment. Before we go over the freehold estates, let's talk about leasehold estates one more time. Leaseholds involve tenants, and a lease signifies the tenant's right to occupy an owner's property for a limited period of time as defined in the lease. Leases involve tenants who are the lessee. The owner is known as the lessor. A lease is considered personal property that is an intangible or incorporeal asset. It is not considered real property ownership because it's not. A lease describes the tenant's right to occupy someone else's property for a limited period of time as defined in the lease, as well as the terms, the length of time, what's being leased, and any limitations on the estate. So let's highlight leasehold estates involve tenants and are estates for a period of time, and leaseholds are considered to be personal property, not real property that is an intangible or incorporeal asset. And there are 4 types of leasehold estates that we're going to discuss later in chapter 12. And they're an estate for years, a periodic estate, a tenancy at will, and a tenancy at sufferance. Those are the 4 types of leasehold estates we're going to go over in a much, much later chapter 12. So everybody got that?
One second. Got it.
Okay.
1 second, 1 second. Okay.
All right.
Oh, Lord.
Start writing. These are the 3 types of freehold estates. The first one is known as simply the word fee simple, or fee simple absolute. It goes by those 3 terms. You could call it a fee estate. It could simply be referred to as fee simple, or fee simple absolute. And this is ownership forever without restrictions. It's the highest type of interest in real estate that's recognized by law. Goes by fee simple, or fee simple absolute. The highest form of ownership recognized by law. It's ownership forever without restrictions.
Owner forever.
Then we have a fee determinable estate. This is ownership forever based on a restriction. That restriction is called a restrictive covenant. So any restrictions placed in deeds are referred to as restrictive covenants. Covenant is a legal promise. So fee determinable also goes by conditional fee or defeasible fee estate. because this type of ownership is based on a condition. And as long as that restriction, that restrictive condition is not broken, then the estate, the ownership continues. But if you violate the condition of your ownership, then the person who sold you the property and put that restriction in it, or maybe who's not the person who sold it to you, maybe it was the person before that or before that. Whoever put the restriction in the deed, if they find out you violated the terms of the sale, they can step forward, take you to court, and compel you to give them back the property because you violated the terms of your ownership, whatever that was. Like, for example, when I told you Shell gas station often sells a gas station, and they put a restriction in the deed that the property cannot be used as a gas station again. Or they say that it can't be used as a gas station again unless it's a Shell gas station again. If they find out later on that you're using it as a gas station or a gas station from a competitor, they could take you to court, and then you have to turn the ownership back over to them, and they pay you nothing for it because you violated the terms of the sale, which you were perfectly aware of. You were aware of it because it was written in the deed itself. So the possibility of you losing the property this way only in the event that you violate a restriction is called the possibility of reverter. Now, the person who put the restriction in the deed would be the one who who the property would go back to, unless they name a third party to be a beneficiary, and that third party would be called a remainder man. A remainder man is a third party named in a document, an instrument, to be a beneficiary. You need to know that term as well, a remainder man.
Remainder man.
It's a third party named in an instrument to be a beneficiary.
Excuse me.
Then we have a life estate. A life estate is ownership based on a life. It's based on someone's life. So a life estate is based on a specific person. The owner of a life estate does not have a right to pass ownership to their heirs because the life estate ends with the death of the owner whose life it is based on. They give you ownership. For example, if I gave you ownership of my property for as long as you're alive, you have ownership of that property for the rest of your life. That's all the ownership, that's all the rights I gave you. I gave you rights to ownership of that property for as long as you're alive. And you could do anything you want with that property with it while you're alive. But you cannot create new rights for yourself and dictate who would then get it after you die, because I only gave you ownership while you're alive. And upon your death, the property comes back to me or my heirs or someone else that I would name to be the beneficiary, which would be called a remainder man. Make sense?
Yes.
Yep.
So let me know once everybody's got all them highlights and notes written down there.
Got it.
Got it.
Got it.
All right. Let's move it along. So to recap, fee simple also goes by the name fee simple absolute. It's the highest form of ownership, the most complete form of ownership recognized by law. It's ownership forever without restrictions. Fee determinable also goes by defeasible or conditional fee estate, is ownership forever, but that ownership is based on a restriction. And that restriction is called a restrictive covenant, which can be added to the deed by private parties, not by governments. Governments have their own powers on how they could restrict how you use your property. Private parties do so by writing it into the deed. So government does not place restrictions in deeds, only private parties do. If the restriction is ever violated, the ownership would revert back to the person who placed that restriction in the deed. This would be called the possibility of reverter, or to a remainder man, a third party named in the document, the instruments, to be a beneficiary. The restrictive condition runs with the land, so it passes on from one owner to the next. So if you bought a property that has a restriction in it based on the ownership, and then you sold that property to someone else, they buy that property. You're only passing on to them the rights that you had, and that was ownership based on a restriction. So if you bought a property that said you can't use it as a gas station, you can't use it as a gas station. Now, if you sell that property to someone else, they inherit that restriction. That restriction runs with the land. So they can't use it as a gas station either, and so on and so forth. You follow? You get my drift?
Right.
So whoever violates it in the future, years down the road, owner passed on to owner, if somebody violates that restriction, they were aware that there was that restriction, they would have to turn that property back over to the person who put the restriction in the deed. If that person's no longer alive, then it would be their heirs or a remainder man that they may have named. And then we have a life estate, which is also a form of ownership. It's based on the life of the person which the estate is measured. They can't leave it by will because when they die, they lose their interest. It's based on their life, right? And they have all the rights to ownership. They could sell it, lease it, mortgage, give it away, but they can't destroy the estate's value. Upon their death, the ownership would revert back to the person who gave them the life estate or to a remainder man. A famous example of a life estate would be Hugh Hefner and the Playboy Mansion. You guys remember him? It wasn't that long ago that he died.
Yeah.
But Hugh Hefner, he was the creator and owner of Playboy magazine. He owned the Playboy Mansion there in Beverly Hills. A lot of raging parties went on over there with all the Playboy bunnies. And interesting little factoid here is that Hugh Hefner actually sold the Playboy Mansion when he was still alive. But he sold it with an agreement. There was an arrangement there that whoever bought the Playboy Mansion from him had to give him back a life estate. So he sold the Playboy Mansion with an agreement that whoever bought it gave him the ownership of that Playboy Mansion back for as long as he's alive. So he sold the property to somebody who bought it from him and then gave him back the ownership in the form of a life estate, knowing that when Hugh Hefner died, the buyer would get the property back. Here, let's take a look at this example. I got a link here to that on the Realtor website, the Realtor.com website. We'll wait for that to open up. There's the Playboy Mansion. Interesting sign. For sale with owner. That's interesting. So the Playboy Mansion came with that life tenant. Now, Hugh Hefner sold his 6-acre crumbling mansion. Yeah, you know, having those constant parties going on for ages and ages, and not updating the mansion at all caused the thing to crumble. It was falling apart. He had those little dogs running around too. They peed and crapped all over the place. So the place kind of stunk. It was dated from the 70s still, this Playboy Mansion. So it needed some serious updating. So he put it on the market for $200 million. I think he ended up selling it for $100 million or just shy of that. But Hugh Hefner sold the Playboy Mansion when he was 89 years old. And he was still living that Playboy lifestyle at 89. Bless him. However, the guy who bought the Playboy Mansion from him, his next door neighbor, gave him back a life estate. I mean, how much longer is Hugh going to live, right? 89 years old. Would you give him back a life estate for that agreement if he gave you a deal on the purchase price?
89 years old, no.
Well, I mean, how much longer is he going to live?
Right.
I'd give him a life estate back. You know, you're going to give me a break on the price if I give you back a life estate that says that you can live there for the rest of your life? I mean, how much longer are you going to live? You're already 89, right? So that's exactly what the neighbor did. And it ended up working out in his favor, the neighbor's favor, because Hugh Hefner only lived for one more year before he died. All right. And this just goes on to say how these arrangements are old as the hills themselves. You know, the life estates, those kinds of things have been around for a long time. So even though that $200 million was the asking price, they said it would probably sell around 80 or 90 million. I think he sold it for just shy of 100 million. So it was in the 90s, $90 million range. And then Hugh ended up living, you look, the average U.S. male's life expectancy is 84.3 years, you know. I mean, he was already past his life expectancy. So, I mean, how much longer you figure he's going to live? So it wasn't a bad deal giving him back a life estate. The guy who bought it, the Playboy Mansion, he was the next door neighbor. He was some Greek guy whose family got a lot of money. His dad was in the business of owning brands, and he taught his kids how to do the same thing. And so the next door neighbor of Hugh Hefner and Playboy Mansion there in Beverly Hills, this guy, he actually owns Pabst Blue Ribbon. They own brands. They don't own they're not in the business of creating companies or anything like that. They just buy and sell brands. They own brands of foods and drinks and all kinds of stuff like that, stuff that people need to survive or want to enjoy. So there's a lot of money in brand ownership.
How do you do that,
brand.
though?
Huh?
How do you even get into that, though?
You got to have a lot of money to begin with, you know. I don't know the father where he got his fortune from, if he came from money himself, or if he borrowed it and knew the right people, borrowed it and bought a brand, made a lot of money with that brand, parlayed it into buying another brand, you know, and brands and brands and brands. Pretty soon you own a lot of brands. You know, look at this. Who bought Playboy Mansion? The guy was in his 40s, 30s or 40s. Let's see. Darren Metropoulos bought the Playboy Mansion at the age of just 25. Imagine having that kind of money to buy the Playboy Mansion from Hugh Hefner for 18 million in 2000. No, it was not 18 million. It was a lot more than that. Let's click on this article, take a look really quick, but that's a misprint. So this young guy had enough money. He owned the mansion next door, and he bought Hugh Hefner's Playboy Mansion here. Let me see. All right, so he's the owner of a bunch of brands like, let's see, Greece-born private equity investor. Okay, so he got his money from private equities. And now he owns brands like Chef Boyardee, Pabst Blue Ribbon Beer, Bumblebee Tuna. He currently has a net worth of $2.4 billion at 20. No, it wasn't 24, 33 years of age. There we go. Damn. I'm 51 and I don't have $2.4 billion. Can you imagine? At the age of just 25, he purchased the property next door to the Playboy Mansion. So he lived there for a bunch of years from Hugh Hefner for $18 million. Okay, so he bought the property next to the Playboy Mansion for $18 million. That's what that was about. And then he bought the Playboy Mansion for $100 million with a stipulation. He gives Hugh Hefner a life estate. Now, he had to also agree that he wasn't going to tear down the Playboy Mansion. So he agreed to that. So instead, he gutted the whole thing and is redoing the whole thing as a landmark. Look, you had all kinds of parties over the years. You had all kinds of celebrities, actors and actresses, heads of states, presidents of the United States and other countries that partied over there at that Playboy Mansion over the decades, you know. Yeah. That's Playboy Mansion there for you. A lot of history. But anyway, there's one example of a life estate where it actually took place in a very famous setting. And there's a spin on the life estate called the life estate per autre vie. Yes, you need to know this term as well. Per autre vie. That is not French, even though there's a term in French that's pronounced the same and it means the same thing. It's only spelt different. So per autre vie, it means for the life of another. This is Latin, a life estate based on a third party's life. So instead of basing it on the life of the person you're giving the estate to, you're basing it on someone else's life. Like for example, if you own a house and you give the ownership of that house to somebody with a condition that they also have to look out for your ailing parent, and you're going to base that ownership on your parent's life. So you're going to give somebody your property with the condition that they have to take care of your parent for as long as they're alive. It's in their best interest to make sure your parent's still alive, right? And then you could give a further directive that they have to live in the house as well, you know. And then that's a life estate per autre vie, the life of another. So life estate, not based on the person whose life it is given, but on someone else's life, a third party's life. So if you guys want to snap a picture of this one slide that has all that stuff with a little bow on it for you to study as a great note, be my guest. And we'll leave that at that for now. So once again, fee simple absolute. Fee simple absolute is the highest form of ownership recognized by law. It's unrestricted ownership forever. The holder is entitled to all the rights in the property. On their owner's death, they could dictate who gets the property after they die. They could pass it on to their heirs or devisees. It's known as fee simple absolute. Ownership forever without restrictions. Fee determinable, also known as a defeasible or conditional fee estate. It is ownership based on a restriction. As long as that restriction is not violated, you're the owner of the property. If you violate that restriction, there's the possibility of reverter, where that ownership would revert back to the person who put a restriction in the deed, or a third party named in the instrument called a remainder man. Life estates limited to the life of the person it's the life estate is given to. The ownership could revert back to the person who placed or was granted the life estate, or to their heirs or a remainder man. The life estate can be tied to the life of a third party. That would be a life estate pour autre vie, the life for the life of another. And then we have the life interest may be sold, leased, mortgaged, given away. It's your property. When you have a life estate, it is a form of ownership. You own that property. You have all the rights to ownership that any owner would have for as long as you're alive. So you just can't leave it in a will because you don't own it after you die anymore. That's the difference there with the life estate. So these three forms of ownership, forever or a lifetime, like with the life estate. So life estate, the ownership is based on the life of a person it's given to. And on page 105, let's highlight life estate pour autre vie, for another's life. A life estate pour autre vie, for another's life. So the holder of a life estate has true ownership of that real property for as long as they're alive. But it always ends on the death of the person against whose life the estate is measured. So let me know when you get this highlighted, this and this. We already got this before. This is on page 105, just underneath that diagram.
One second.
Mm-hmm.
I'm good over here.
All right. So the reversionary interest works like this in a life estate. The grantor is the one who would give you the ownership. They would give that to a life tenant, and upon that tenant's death, the estate goes back to the grantor. Or it could be set up like this. The grantor gives the life estate to a life tenant, and upon their death, it could go to a third party, called the remainder man. Dower and courtesy. Dower, once again, is that ancient right in New Jersey that was abolished. New Jersey abolished the creation of any new dower or courtesy rights. But these are the ancient rights that a spouse has in their spouse's property. Dower is the wife's interest in the husband's property upon his death. Courtesy is a similar right that the husband has in the wife's property upon her death. And New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980, a date you need to know. And you need to remember which one is the wife's right and which one is the husband's rights. And I told you the way to remember this is dower begins with a doe, and a doe is a deer, a female deer, and courtesy, because men should be courteous to women, that's the husband's right. All right, so let's highlight this on page 105, and then let's see, this is down on 106. But
After this, can you go back for like got it.
okay. So let's highlight this on page 105. and underlined Dower and courtesy and May 28th, 1980. Everybody got that?
Yes.
Yep.
All right, now let's learn about what an encumbrance is. Turn the page. Now don't even look at the definition of encumbrance, please. Please don't look at it. I'm trying to teach you a way that's better for you to remember what an encumbrance is. First of all, forget about real estate for a moment. Anybody ever hear the term encumbrance before? What is an encumbrance? Anybody know?
I haven't heard of this.
If you're encumbered by, say I jump on your back and I hold on, you're encumbered by my weight. Just to give you an idea. So what is an encumbrance?
Something that limits you, holds you back, stops you.
Yeah, something that limits you, holds you back, makes it harder for you to move, right? So just keep that idea in your head. You know, if I jump on your back, you're encumbered by my weight. It makes it harder for you to move. But let me ask you a question. Can you still move?
Yes.
Sure you can. It's just harder to. Now, apply that same scenario to real estate without learning any real estate encumbrances yet or discussing any real estate encumbrances yet. If real estate's encumbered by something, can you still move it, sell it? Yes, it's just harder to. Okay, so we're going to apply that same scenario to real estate. So if I jump on your back, you're encumbered by my weight. My weight is making it harder for you to move, but you could still move. It's just harder to. So if real estate's encumbered by something, can you still move it, sell it? Yes, it's just a lot harder to. Now that we have that understanding down, it'll make it easier, hopefully, to remember that. So what are encumbrances pertaining to real estate? Well, an encumbrance is a burden on the property. It's a claim, lien, charge, or liability attached to and binding on real property that could limit its value or title. A lien is a financial claim on property. A lien is a financial claim on real property. You have mortgage liens, tax liens, lawsuit judgments, mechanics liens. That's like a contractor's lien. If you don't pay them to do work on your house after they did work on your house. Then we have physical or usage encumbrances. That includes deed restrictions, easements, licenses, and encroachments. So we have liens, which are financial claims, but then we also have physical or usage encumbrances for property, like a deed restriction, an easement, license, or an encroachment. So we're going to learn about easements and licenses and encroachments in a little while. We already learned about deed restrictions. Those are restrictions that could limit how you could use the property. So that's a usage restriction. So these restrictions do affect the property's value and or title. And here's a little brain teaser for you. All liens are encumbrances, but not all encumbrances are liens. Well, that's true. Let's just try to define these words in our head as we read them. All liens, financial claims, are encumbrances, burdens on the property, but not all burdens on the property are financial claims. You see how I did that to better understand it? I'm defining the words as I'm reading them. And you guys should do the same thing on exams if you could. If you see a question with all kinds of words in there like this, define them in your head as you're, break down the question by reading the question, by defining these words, redefining them so you better understand them. And then you better understand the statement. Like this sounds like a brain teaser. All liens are encumbrances, but not all encumbrances are liens, because these words are fairly new to us. But if we break it down that way, all financial claims are burdens on the property, but not all burdens on the property are financial claims. It's easier to understand, isn't it? So that's the way you should break things down in exams. Make them easier to understand. And let's do these highlights on page 106.
How did you, what did you say you wanted us to do? Just the top line for encumbrance instead of the
Yeah.
full definition up there?
An encumbrance is a claim, lien, charge, liability attached to and binding on real property.
Just that
Liens
top line right
are
there.
financial
Okay.
claims, and physical usage encumbrances include easements, encroachments, and licenses. Now, lien is a financial claim against property that provides security for debt or obligation of the property owner. So if that obligation is not repaid, the lien holder or creditor has the right to have it paid out of the property, usually from the proceeds of a court sale. Real estate taxes have first claim against the proceeds of such sale, because two things are certain in life: death and taxes. So liens are classified as either voluntary or involuntary, and as general or specific. So what is voluntary? Voluntary is something you wanted. Involuntary is something you did not. A general lien affects all property you own. A specific lien affects only one parcel, one piece of property. So let's do all these highlights. Page 106. Let me know when you got all that.
One second, just on generally. So everybody got all that? Yes,
Yeah.
I'm done. I'm sorry.
So a lien is a financial claim on property that provides security for debt or obligation of the property owner. And once again, those liens can be voluntary That's one that's created by the owner, or involuntary, one that's created without the owner's consent. And then general liens affect all the property you own, and specific liens only affect one property. See, general liens could affect all property you own, including your car, your bank accounts. It's a real and personal property it could affect. So how do liens affect your title, your ownership of your property? Well, encumbrances, liens, and other kinds, they run with the land. Get used to that term, running with the land. That means it goes with the real estate. They pass on from one owner to the next. So liens attached to the property, not to the property owner. Everybody got that?
Yes.
Yep.
Yes.
So just to recap again, encumbrances, liens, and otherwise, they run with the land. Liens attached to the property, not to the property owner. Real estate taxes have first claims against the proceeds of such a sale. Liens that are voluntary are ones that you created, something you wanted, like a mortgage lien, you went out of your way to get that, or a home equity line of credit, you went out of your way to get that. Involuntary liens are ones that you did not create or you did not want, but you still got to pay them, like real estate taxes, unpaid federal income taxes, IRS liens, lawsuit judgments, or child support. These are liens that could affect all the property that you own, not just one. Now, when you have a lien that's on your property and that lien is paid off, like your mortgage loan, a satisfaction of that lien, meaning that it's been satisfied, it's been paid off, is recorded in the public record, showing that there's no longer any debt on the property, because a lien is a financial claim, right? So there's no longer a financial claim on the property. They never remove the lien once it's been paid off. It's there forever. All they do is they add another document to the public record saying that the lien had been satisfied, that it's been paid off. So once you pay off a loan, a lien that's already on the property, once a lien is on the property, once again, it is never removed. They just add another document to the public record stating that the lien had been satisfied, it's been paid. This way, anybody searching in the future can see the complete history of this property. There was a lien on the property had been then paid off. That's the way it goes with anything that's added to the public records. Anytime a document's added to the public records, it's there forever. You can't get a document removed from the public records. Once it's there forever. All they'll do is add another document to the public records explaining what's going on. It's been paid off, for example. And any lien on the property creates a cloud on the title. Okay, what do I mean by cloud on the title? Well, anytime you hear that term, cloud on the title, think of like the cartoons when you were growing up as a kid. You ever see a cartoon that had like a dark thunderstorm just like hovering over one person's house? It was spooky. Well, think of it that way. Would you want to buy a house that has that dark thunderstorm cloud only hovering over it? Or is that kind of like an indication that there may be a problem with that house? You know, so if you're buying a house in real life and it's said that there's a cloud on the title, title means ownership. Cloud on the title means there's something in question about that. It's not clear because it's cloudy out, right? There's a cloud hovering over that ownership of that real estate that we need to get that cleared up before we go through with the purchase on that property.
Question.
Yeah. Go ahead.
Would they ever use the word cloudy on a title? Like, would they ever phrase it like that?
Cloud on the title. Yep. They want you to know what a cloud on the title is. It means that there could be a question pertaining to the ownership. Maybe somebody's claiming that they're the rightful owner of the property. So there's a lien on the property that has not been paid off. There's a cloud on the title until that thing gets paid off, or it's established that it already had been paid off. It's indicating that there's a problem, and that problem needs to be cleared up before would you want to go through with the purchase of a house if it said that there's a cloud on the title, that the ownership is in question on that property, or the fact that there may be other liens on the property still that's in question? Or would you want to make sure that that's cleared up before you go through with the purchase?
Cleared up.
Yeah. So that's basically what a cloud on the title means. Okay. All right, here are some different forms of involuntary alienation. If a person dies intestate, that means without a will, and no heirs, through the process of escheat, the state will take the property if no heirs step forward, right? Then, if a land is needed for public use, how does the public acquire that land? They do so using their powers of eminent domain. And when they take the property through the court system, it's called condemnation. Condemnation is a lawsuit for taking that property through the court system, but the owner of the property has to be justly compensated. And who has the powers of eminent domain? Who's taking that property? A public or governmental agency. Now, we also learn now that the public or governmental agency is not necessarily the one that keeps it. They could always pass that on to somebody else. They could use their powers of eminent domain to take the property and then give it to somebody else. Then we have non-payment of a debt, where the real estate is the security for that debt. Through the process of foreclosure, foreclosure is a court proceeding to take back ownership of a property that's secured for the debt, and then that's sold at an auction by the sheriff's department for the highest bidder. Then that money goes to pay off those people who are owed money, and any remaining balance would actually go back to the property owner that was foreclosed upon, if there is any excess balance. And then through open, notorious, continuous, hostile, and adverse use of another person's property for a prescribed period of time as outlined by the law, through adverse possession, an adverse possessor can claim the ownership of that property. Now, what determines the priority of liens? What is a priority of a lien? Priority determines the order in which liens are repaid. So basically, if there's a bunch of people who are owed money and there's a bunch of liens on the property, who gets paid back first? Whoever recorded their lien on
We
the
recorded it with the court first, right?
well, not with the court, whoever recorded it in the public records. You go down to City Hall and you record it. There are property records. It's kind of like a library for keeping all the records of property ownership. And the librarian down there, I'm just going to call them a librarian, who maintains those records, would allow you to record your interest in the public record. So if you have a claim to put on that property, anybody who has an interest in real property can record their interest in that property in the public records. And And if you won a lawsuit and you got a judgment against somebody, okay, great. You got a piece of paper that says they owe you money. Now, if you find out they own real estate, you could take that paper you got from the court that says that they owe you money, and then you could turn it into a lien on the property. But that's a separate action altogether. You'd have to go down to the record keeping department and for the real estate, and you'd have to turn it into a lien. You pay the filing fee and you turn it into a lien on that property. Now, who gets paid back first is whoever recorded their lien first. And mortgages usually have the first lien position because at the time you bought the property, there was no other liens on the property. Your lender usually won't give you a loan unless all other liens are cleared off the property first before you buy the property. Now, there's an exception to the lien repayment order. Real estate taxes. There's two things certain in life, death and taxes. You will all die and you all got to pay your taxes. So in the event of foreclosure, who gets paid back first? Taxes jump to the head of the line. It does not matter what other liens are recorded before them. Taxes always jump to the head of the line, the head of the list. It's certain that they must be paid. Okay, so those taxes, they got to be paid. And then mechanics liens, they're unique in that they also go according to their recording date, kind of. Because a contractor can go and record their lien at a later time, and then their lien jumps ahead of others. It could jump ahead of others because it doesn't go according to the date that they recorded the lien. It goes according to the date that the materials were delivered or the work was performed. So they're retroactively dated. So they're unique in that regard. So all liens are, their priority is determined by the date they're recorded in the public record, with the exception of real estate taxes, which jump to the head of the line, and mechanics liens, which are retroactively backdated to the date the materials were delivered or the work was performed, whichever occurred first. So you guys have these highlights here for the
Yeah.
priority on page 107.
1 second.
Yes.
State taxes first. Mechanic.
Got it.
Wait a minute, 1 second. Mechanics contractor.
Let me know when you got it.
You said that the contractor's mechanic is the priority is retroactively backdated to the
Yep.
date when the work
To
was
the date that the work, we'll have a place to highlight that. You don't need to write that down right now.
Okay.
If you want to, you can snap a picture of that, but we're going to highlight a statement pertaining to that as well.
So does that mean that if someone's doing work on your property, right?
Uh-huh. And
Um,
you don't pay them for
or
the work that they did, they could file a lien against your property. Could that create a problem if you try to sell
Right.
the property now?
right, it could, but
Yeah.
does that mean, do they have a certain amount of time to do that, or does that?
Well, they don't have to do it, but it's in their best interest to, if you're not paying your bills, for them to go and record that lien in the public record, right? So, I mean, if you didn't, if you
No, but I'm
did a
asking, is there a
remodel-
certain amount of, is there a time frame?
No. You didn't do the work on my house, I'm gonna go record it in a public record.
Is there a time frame though? Like, is there a time frame from?
what, a time frame for
Right.
me to file it or wait to file?
Yeah,
it?
to file it. Yeah. Is there like a statute of
No.
limitation for the time frame for that?
No, you didn't pay me back. You owe me money.
So
Uh,
if it's 20 years later, 5 to 20 years later, they can still do that.
whenever I get around to it, if I could prove that you owe me the money, then you owe me the money, you didn't pay your bill. Doesn't matter how long ago it was, you didn't pay your bill, you owe it to me. Now, if I took you to court over it and I got a judgment against you, remember, contractors don't got to do that. They could just get a lien against you because, hey, you hired them to do work and you didn't do the work. But if they went to court and they took you to court and they got a judgment against you, now judgments usually have a statute of limitations on them. But look, if you get a judgment against somebody, the judgment is usually generally good for, I believe it's 15 or 20 years. But then all you got to do is file paperwork to renew it for another 15 or 20 years. So no, there's no time limit on it. You owe somebody money until you pay them back. It's that lien can be perpetual there forever. They just got to renew it. If they never took you to court on it, all they got to do is file the lien. They're just making a claim you owe the money. You need to, if you want to get it removed, you need to clear it up. If you got a problem or a question that it's legitimate, then you take them to court. I'm sure they would love for you to do that if you owe them money. You try to take them to court to get them to remove the lien,
Wow. Okay.
So that's the way that works. All right, so liens get filed, recorded according to their priority. So if you do a title search, you could see all the documents that are in a public record. And a title search is basically where somebody goes down, they search the public records, and they make a list of all the documents that can be found in the public record pertaining to that property, and they put them in chronological order according to the date. Liens and other encumbrances, they run with the land. That means they pass from one owner to the next. So you need to you probably need to pay that off if you want to be able to sell that property, because anybody who's going to buy it's going to do a title search most likely, and they're going to uncover it. That's why caveat emptor, it means let the buyer beware. If the buyer wants to find out if there's a problem with the ownership of the real estate, it is up to the buyer to do the title search and find it out. So the priority of those liens are repaid according to their priority, and taxes take priority over all other previously recorded liens. Otherwise, they're paid according to the date they're recorded in the public record, with the only exception other than taxes being the mechanics lien, which its priority is retroactively backdated to the date the work began or the materials were delivered, whichever happened first. And they don't have to go get a judgment against you. They could just file a lien. Hey, I got a bill. I got a bill for you. You didn't pay the bill. You want to argue the fact that I did the work or not? Sure, let's do that. You could take me to court. But as of right now, I'm not doing that. I'm just filing a lien on your property. So you try to sell that property or refinance it or do anything with it, you're going to have a problem, because it's showing that there's other liens on the property already. And mortgage liens, judgment liens. A judgment is a decree from a court, basically a letter saying that you owe someone else money. So a judge rendered a decision, you owe somebody else money. That's what a judgment is. And those judgments can be turned into liens against the property. Did you know that if you owe somebody money and you don't pay them back, you could get a lien against, you could get a judgment against them. You take them to court, you get a judgment. If you get a judgment, you could try to find out if somebody owns money or has property or has some sort of asset. And then you can try to get them to pay if they have an asset by filing a lien on their property. Or here's an interesting thing. Did you know that you could also hire somebody to track down if that person who owes you money has any other assets and have them be your personal debt collector, your enforcer, so to speak? And that person would be the sheriff's department. If somebody owes you money and you got a judgment against them, you could go down to the sheriff's department, have the sheriff's officers use their police tools to do background checks and check banking records and everything to find out if you have any assets, if that person has any assets. And then they can put a lien on those assets. They could take money out of your bank account. They could file a lien on your property. Now, they're not doing it for free, though. There's a 10% fee involved with that. For whatever money the sheriff's department can collect for you, they get to keep 10% of it. So sheriff's departments do stuff like that. They also do evictions. They also enforce they enforce all kinds of court orders, whether it is collections of debts and assets recovery or evictions and things of that nature. All right, so page 108. A mortgage lien is a voluntary lien. Construction lien is also known as a mechanic's lien, and construction liens are unique in that they're retroactive to the date the work in question originally began or when the materials were delivered. See, you didn't have to write that note. You could just highlight it right here on page 108. Let me know when you guys have all those highlights down.
Good.
Okay.
Whew.
Got it.
A lis pendens. This is new. A lis pendens is a public notice of possible future legal action. So when you fall behind on your mortgage payments, a lender will usually file a lis pendens in the public records. It basically says you're behind on your mortgage payments, and there may possibly be a future legal action pending. What would that legal action be, would you think?
A lien.
Well, a lien is a judgment from a court.
I mean, I'm suing. There's somebody suing you.
It would
Foreclosure.
Foreclosure. So that legal action would be foreclosure, because foreclosure goes through the court system. That's the process of regaining collateral ownership of something as collateral for a loan, right? So, as a real estate agent or as a real estate investor, would it be valuable to you if you could get your hands on a list of all property owners who are behind on their mortgage payments and in danger of foreclosure?
Yeah.
Well, there is such a list. It's called these actions are called lis pendens, and there are lists that you could buy from companies that hang out down at the 21 halls of record keeping in the 21 counties that we have here in New Jersey. And anytime that a lis pendens is recorded, they're down there to get it, and they add it to their database, and you could subscribe to these databases. And here it is. njlispendens.com and realtytrack.com are two of the popular ones out there that do such things. So once again, what is a lis pendens? It's a public notice of possible future legal action. That legal action being foreclosure.
So it's like the pre-foreclosure list.
Yeah, kind of. Yeah. This is just a notice that, hey, for interested parties, if you're looking into buying this property, They owe us money still. And so there's going to be, you better make sure that they pay us back, because liens attached to the property, not to the property owner. So in the event you buy this property and that lien is not cleared up, you're going to be responsible for it. So now if you're that buyer, are you going to try to put pressure on that seller to make sure that lien is cleared up first?
Yeah.
Good, then I'll get paid back finally. You see how that works? All right, let's talk about easements now. An easement is a right. It's a right. You're going to highlight this on page 109 and underline the word right after you highlight the sentence, after you highlight it so you don't smudge your ink. So highlight the sentence and then underline the word right. It's a right acquired by one party to use the land of another for a particular purpose is an easement. And there's two classifications of easements. They could either be appurtenant or engross. Now keep in mind, an easement is a right. Rights can't be revoked. Nobody can take your rights from you. They can't take them away from you. Once it's established you have rights, nobody can take your rights. They're your rights. You can give up your rights, but nobody can take them from you. You have the right to remain silent. And if you give up that right, so they're your rights. Nobody can take them from you, but you can give them up. All right. So we have two classifications of easements. They could be appurtenant or engross. So what does that mean? Well, let's first go over an easement. Let's go over this one first. It's a little bit easier. An easement engross on page 110. Highlight an easement engross and then right next to it, utility easement. You know, like public utilities for water, sewer, gas lines, electric, cable, whatever. If the need for these easements were to cease, the easement would cease to exist. So this type of easement right would be an easement that would allow them to put a telephone pole on your property, or having a gas line or water main or something going under your property. Okay, then go back to page 109. An easement that grants the rights of the owner of an adjacent parcel of land is an easement appurtenant. Adjacent is another property that's touching yours, not the person across the street, but maybe your neighbor to the left, your neighbor to the right, or the neighbor behind you. It's not the person across the street. It's another person's property that's touching yours. So an easement is a right. Nobody can take those rights from you. An easement appurtenant is an easement where between you and another landowner whose land is touching yours. And it's a right for them to cross onto your property for a particular purpose that you may have given to them. The person who has the right to cross onto someone else's property and use their property, they're the dominant estate. They're the one that's benefiting from the easement. And the one whose property is being walked over, well, they're the servant or servient estate. So there's always two estates, a dominant and a servient. Which one benefits from the easement?
Say that again.
There's two estates in land, the dominant estate or the servient estate. Which one benefits from this easement right?
Servient.
The servient.
The dominant. The servient is the one whose property is being walked all over and being used up.
Oh, okay. So
Oh, the way I read it was
I-
off.
Yeah.
I thought dominant was the dominant. Okay.
Yeah.
Servient is
Hey,
the
look,
one you.
I push you out of the way. Get out of my way. I'm crossing over your property. You know why? Because I got a right to, and you can't stand in my way. I'm just exercising my rights. I'm not being a bully. I have a right. That right was given to me. You can't stand in my way now to try to take that right away. I'm just standing up for myself. So I'm being dominant in that way. So that's the dominant estate. The servient estate is you. It's your property. I'm walking over your property. Well, because I have the right to. So you can't do anything about it now. So it is what it is. And easements run with the land. So even if you sell that property now, that easement right passes along to the next owner. It doesn't like reset it and the right goes away or anything. That right passes on from one owner to the next. So easements are either appurtenant or engross. Engross is a utility easement. Appurtenant is one with neighboring properties that are touching each other. And there's always a dominant estate and a servient estate. And which one benefits from the easement? The dominant estate. The servient is the one whose property is being walked over or used. Now, so we're going to go over the easement by prescription, which we already went over before, but we're going to go over it again here a little more detail. The easement engross, we just went over that. That's a utility easement. We're going to go over an easement by necessity, which falls under the easement appurtenant. We're going to talk about party wall agreements and how to create or terminate an easement. So the easement is a right acquired by one party to use the land of another for a specific purpose. It's usually in writing and it's written into the deed itself or in a survey. And these rights cannot be taken away from you. You could give them up, but they can't be taken from you. A license, on the other hand, is permission, like your driver's license gives you permission to drive. It's not a right. You don't have a right to drive. That's permission. So a license is permission to enter the land of another for a specific purpose, and often these things are verbal. They don't need to be in writing. Hey neighbor, how you doing? Feel free to come over my property anytime you like. You could hop in the pool even if I'm not at home. I just granted you a license for a specific purpose to enter my land to use the pool, even if I'm not at home. Now you kind of been abusing that right and you're leaving a mess and we get into a fight and I say, you know what? I don't want you on my damn property anymore. I just revoke your license. It's as simple as that. It doesn't need to be in writing. I just told you can't use my pool anymore. I don't want you on my property anymore. That's how a license works. Somebody can take away your license. If I gave you a right and put it in writing, I couldn't take that away. But permission, a license, can be taken away. Okay. So let's do these highlights on page. You already got this one on 109. Now on 112, I want you to highlight this one. A license can be revoked. It's permission to enter the land of another for a specific purpose. And underline the word permission, because a license is permission. Easement is a right.
Where's-
Page 112.
No, I was looking at.
After this, can you go back for a second?
Sure. Just let me make sure everybody's got this on 112.
Yep. 10, 12. Yep.
Okay. You want me to go back here?
Yep. All right, thank you.
You're welcome. All right, let's advance. So easements, once again, is the right acquired by one party to use the land of another for a particular purpose. Easements, when they're created, they run with the land. So even if you sell the property, it passes on to the next owner, that easement right. And they have the right to exercise that right that they've inherited because it ran with the land. They inherited it with the change of ownership. A party could also have an easement right in the airspace above the land or subsurface easement right to what's beneath it or in it, like a mineral right. The holder of an easement only has rights and not an estate or ownership interest in that land over which the easement exists, giving them the right to cross over it or use it. And easements fall into two categories, either appurtenant or engross. We learned that easement engross is what? It's a utility.
Is that the dominant?
No, easement engross is the utility easement. For public utilities, like power lines, sewer lines, gas lines, water lines, etc., to run over your land. It's needed for the greater public good. But if that easement were no longer needed, then the easement would cease to exist. An easement appurtenant, that's the one with the dominant and servient estates. Highlight an easement is said to run with the land, page 110. Easement is said to run with the land. So in this picture, you could see an easement appurtenant. Lot owner B on the left, lot owner A on the right. Lot owner B has an easement appurtenant to cross over lot owner A's property to use the lake. Who's the dominant estate and who's the servient estate there? Lot owner A or lot owner B? Who is the dominant and who is the servient?
Is A dominant?
A's property is being crossed over. They're being walked all over by lot owner B. B is the dominant and A is the servient. A is the property that's being walked over and used, so therefore they're the servient estate. The one that benefits from the easement is the dominant. So lot owner B is the dominant estate in that regard because they get to cross over onto lot owner A's property to use the lake that's on their property. In this example, easement engross, you got the utility easement right over here. It crosses over both lot owner A and B's property. It is a utility easement, whether that's power lines or telephone poles, telephone lines, I don't know. But it's a utility easement. Now, if they changed it so that the power lines ran a different way, or maybe they didn't need power lines anymore because they came up with some kind of new technology or something, who the hell knows? If that were the case, then the need for that easement would no longer exist, And so then those telephone poles would not have to be there anymore. An easement by necessity, this isn't a real good example of an easement by necessity, because you'd question, well, why can't I just cut down the trees? Oh, I'll tell you, because there's a bunch of environmentalists that would tie themselves to a tree and they would strap bombs to their chests. And if you ever try to dare to cut down a tree and hurt that poor tree, okay? There's all kinds of whack jobs out there to do stuff like that today. So let's just pretend that that's the type of scenario here. So it's impossible for you to create a driveway to go directly to your property. So instead, you would need to create a road that goes over your neighbor's property. You'd have to cross over your neighbor's property to get to yours. That's an easement by necessity. It's usually for landlocked properties where there's no other way to get to your property unless you crossed over a neighbor's property.
So wouldn't both of them be walking over both and both being walked over? Because he's
Well,
using
no, lot owner B, they could come right off the public road, right off the street here, right into their driveway. Lot owner A, however, in order to get to their driveway, to get to their house, their property, they can't do it because all these trees are in the way, and you got all those environmentalists strapping bombs to their chest that wouldn't allow you to cut down a tree. Okay, so the only way for them to legally get to their property is they'd have to cross over your neighbors. Okay, so that's why it's I have to create some kind of stupid scenario like that for with trees. It would be better if there was like a river over here, you know, or something that would make it harder for that scenario to take place. I think I got some better examples coming up. Here we go. An easement by necessity. Here's an example. You have lot owner A and lot owner B. Lot owner B's property is completely surrounded by lot owner A's property. So how would lot owner B get to their property? Well, they're completely landlocked. Their property is completely surrounded by other property owner. The only way to get into their property is they have to cross over lot owner A's property. So lot owner A now has this makeshift road that lot owner B now crosses over to get to their property. Can lot owner B park their car right here in that road that gets them to their property? No, because it's lot owner A's property. You can't just park your car there. You can use it to just for the purpose of ingress and egress. That means entrance and exit to get into your property and to get off of your property. That's it. So come winter time, if it snows, who's responsible for clearing that roadway? Or if a tree falls over onto it, who's responsible for clearing that roadway?
Lot A.
Lot owner A. Why is that?
because he owns all
'cause
of
that's
it.
his property.
Because that's their property and they're responsible for maintaining their property. And they got to keep easement rights clear. Yep. Correct. Here's another example that we commonly see. Shared driveways. Got lot owner A this time on the left and lot owner B on the right. Neither one has enough land here to have a driveway wide enough where they could get to the back of their parking lot in their backyard or to their garage in their backyard. So, but each of them, if they create a driveway over part of each of their property, they'll have enough room for a car to drive over it and get to their backyards and their driveways and their garages. This is called a shared driveway. In this type of scenario, both are dominant and servient to states at the same time, because they're both crossing over each other's property at the same time. Better have a good neighbor here. And then we have the easement by prescription, which we went over in chapter 20 as well. Remember with the adverse possession, the squatter's rights? If you're using someone else's property for a period of time as defined by law, you could claim ownership of that property if that use is continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. Additionally, the use has to be visible, open, and notorious for the prescriptive period of time as required by law. In New Jersey, it's 30 years if it's improved land, 60 years for unimproved land. And through the process of tacking, successors in interest can add on one person's time of possession to that of the other, combining them to reach that prescriptive period. An owner can prevent somebody from gaining an easement by prescription and taking ownership of their land simply by taking legal action against any adverse possessor and removing them from your property, or cutting off their direct access, maybe putting up a fence that prevents them from coming on, or giving them permission. You can't claim an easement by prescription when an owner's given you permission to use their land. All right, so this is what to highlight on page 110 and 111. Easement by prescription, you could give that little cross reference. Also see chapter 20, page 373. That's where we did a highlight there before. And then do the highlights. These are the same notes that I just read to you. We're just putting down those notes. If you could. If you would. Just let me know when you got all the notes, if you would. If you so kind.
Victor, you have at the top of this conflict in law, see page 373. That's what we did earlier about the current.
Yep,
Well,
we did that in chapter 20. So you're just going to write here next to the title easement by prescription, see chapter 20, page 373.
Right. Okay, so that would be in conjunction with the current 30 years improvement.
Correct. It's
Okay.
just the same thing, just they spoke about it on chapter 20 as well.
Okay.
Done.
Mhm. Let me know when everybody's got it.
I'm good.
You're good? All right. Everybody else is good as well, I assume, since you're all quiet.
I got it.
Okay. And so this was in chapter 20, what you highlighted in the notes you took there in chapter 20 as well. That to gain an easement by prescription, it's a form of involuntary alienation. You had to use that, somebody has to use your property for 30 years if it's improved lands, or 60 years if it's unimproved lands, to claim ownership of that land that they've been using. Their use must have been visible, open, notorious, hostile, adverse to the owner's title, and without their permission for that continuous period of time. And then you need to take them to court to perfect this easement. It is not automatic that you become the owner because you've been using it for a period of time. You need to claim that ownership in a court of law to get that ownership granted to you, which is not as easy as you think. And through tacking, if you alone were not the one that was using that property that whole time, you could tack on someone else's time to that of yours if you were successors in interest, to reach that combined period, to reach that amount of time that's necessary. The process isn't automatic. You got to go to court. That suit is called a suit for adverse possession or to quiet title. You can't claim an easement by prescription against publicly owned property. In this example here, here's a listing that I had in Piscataway once. I believe that was Piscataway. Yeah, it was Piscataway. The person had what appeared to be a corner lot, but actually the corner lot was owned by the city. They owned the land over here, and it seemed like a very wide corner lot, which they also cut the grass for. They even had a volleyball net set up over there, but they didn't own that lot. That lot is city owned. So we had to make sure that it was a point that was made, that the corner lot was separate and owned by the city and not part of the sale here, because it seemed like it was part of it, and we just didn't want to have any kinds of misinterpretation there. Now, if they wanted to, they could go to the city and ask the city to grant them the ownership. Whether they do it or not and how long that process would take, I'm not sure. But when the city gives land to a private individual, they do so by public grant. In this example, dedication is when you give land to the government for a public use, such as streets, schools, and parks. And we have a small subdivision here in this example where an owner of this lot, this big square lot, subdivided it and they subdivided it into 6 smaller lots and built 6 houses, and they put a cul-de-sac street here. So do they keep that street private, and now they need to continue to maintain it, be responsible for shoveling snow, for plowing the snow, for repaving it over the years and all that? Or does it make more sense after you sell all these houses just to dedicate that land that's on your property, that street that was built on your property, to the municipality, and now it's a public street, and the city's responsible for maintaining it? See, anytime you get a subdivision plans approved, you need to put down on those plans whether you're going to dedicate the land, any land, or keep it all private. You'd still be able to name the street if you wanted to, because you made the street. But that's what dedication is, giving the land to the government for a public use such as streets, schools, and parks. All right, check this out. Your little cash cab trivia for you guys.
What term for it?
All right, so let's put up the volume on this a little bit better so you can hear it a little better. See if you guys can get the trivia.
What term for a dead-end street means bottom of a bag in French?
What term for a dead-end street means bottom of the bag in French?
Say that again?
What term for a dead-end street means bottom of the bag in French?
Cul-de-sac?
It's cul-de-sac. It is, cul-de-sac is correct. So,
There you go. You just won $100.
Where's my money?
Well, if you were on the game show, you would have just won $100. Please correct that.
what
Now, here's one more term for you.
these expressions are worth $50 each. One Chinese spatial philosophy.
What Chinese spatial philosophy is used to determine sites for graves and house design?
Say it again? I'm sorry.
What
What was the
Chinese
question?
What Chinese spatial philosophy is used to determine sites for graves and house design?
Sites for great houses. I don't know that one. Easement?
What Chinese spatial philosophy used to determine site for graves and correct.
She said feng shui. Feng shui, that is the Chinese spatial
Feng
philosophy
shui.
to determine sites for graves and house design. Yep. You ever hear that, feng shui?
That's none of our terms.
No, we don't need to know that in for our but you need to be aware of cultural differences and cultural diversity and stuff like that for real estate. Because it doesn't need to be important to you, but it needs to be you need to be aware of things that are important to your potential clients and whatnot. Because people who follow feng shui principles, or if they're Indian folks, they may follow something that's called Vastu. And that's similar. It's very, very similar to feng shui. It's just much different reasoning behind it. But the principles are basically essentially the same. They just have different reasonings behind them. One is religious reasons, one's the guru told me to do something, and other ones, they have their different reasons for it. It doesn't matter what their reasons are. It just matters that if it's important to them, you need to know about it. And I'm going to tell you why. I've wasted many, 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 many hours showing people houses of properties before, only to find out later that they would never place an offer on that property in a million years, no matter how much it was in their price range and met their or exceeded their desires of what they were looking for in a house. And the reason was because the direction that the front door faces.
Oh, okay.
Okay, that's a part of feng shui, the front door, and same thing for Vastu. If the front door is facing south, they'll never buy the house if they follow feng shui or Vastu principles. East is the best. And any other direction for that matter is usually good. Just south, and then south is the worst. They won't buy it. West is but they may consider it. North is okay, and east is the best. It just works like that. It's the direction the front door faces, not the front of the house necessarily, but the front entrance, the front door. When the door is to your back, you hold a compass in your hand, and then whatever direction the front door is facing. Okay. But so those are probing questions that you should ask to your potential buyers. Does it matter to you what direction the front door faces? Because if they say yes, then you could save yourselves hours and hours of time simply by doing a little more research. When you pull up a listing, if it doesn't say specifically in the listing, you may want to pull it up on like Google Streets or Bing Earth and find out which direction, pull up that house and look at the direction that the front door is facing, and you could just say, okay, we can forget about that one. The front door's not facing the right direction on that one, and save yourself time setting up appointments, then taking them out there and getting them to the property, showing them the property. Then last thing they do is look at what direction the front door faces, and then they're not going to buy it anyway, and you just wasted all that time, So you could save yourself a boatload of time if you do the little legwork at the beginning. So ask questions to people. Usually people that follow Feng Shui and Vastu principles will also never buy a house or may have certain other requirements, like the address of the property. The number of the address in the property could affect whether they're going to buy it or not. Or you'd have to set the closing date for certain gates or not to be on certain dates, depending on numbers, because it also deals with numerology. I'm not going to talk negative about it or why. I'm not going to call them superstitions or whatever, but it could be religion. It could be like guru advised me, whatever the reason is of it. You just need to be aware that it's important to them. And if it's important to them, it could affect your business. So you need to respect that. Okay. So you just need to find out if it is something that is important to them so that you can make it important to you, because you closing on that property and making money is important to you, ain't it? So now, and therefore, it's important to you now, right? So just keep that in mind. There's a lot of other principles to that, but that's not what this class is about, to go over all those things. So you can take classes, though, for learning about Vastu and Feng Shui for real estate agents. All right, so pertaining to that easement by prescription, we have lot owner A on the left, lot owner B on the right. The property line is separating them right here, but there's a fence that's clearly put over here. Now, I don't know who put up that fence, lot owner A, lot owner B, or a previous owner of one of these lots. It doesn't matter. If that fence is there for at least 30 years, lot owner A can claim ownership of this strip of land. They could take them to court and claim ownership of it. How could lot owner B prevent that from happening? Well, one, they could take lot owner to court to get them to remove the fence, or they could give them permission to use that land, or they could cut off their access by putting a fence where it actually belongs, right on the property line, and then get them to remove that fence off of their property. But you never know. It could have been a previous owner of lot owner B that put that fence up. They just put it inside the property line, trying to be a good neighbor. Okay, here's an attorney that explains that a bit about how easement by, these easement by prescription cases take place from a legal point of view. Yeah, it's not the best audio, so just let me know if it's coming across all broken up. But I know it's not the best audio, so I'm going to try to keep the volume up there good enough so that you can hear it, because I know it fades in and fades out a bit. But this is an attorney that explains how these types of easements work and why they're in place.
An attorney or for just a property owner, I think a lot of times people don't even realize that this body of law exists. Maybe when you own your first home or you get your first survey, you start to realize how important boundaries can be. My name is Jessica Shrestha. I'm an attorney at Wheeler, Van Sickle, and Anderson. I'm here in Madison, Wisconsin. The concept of adverse possession is that first you start, everyone has a deed to their property. There's a legal description, there's a boundary, whether it's a lot or something else, specific distances, and that's your boundary. But as everyone knows, it's hard to figure out where those are, and a lot of times actual occupation on the ground doesn't necessarily match the real boundary lines. Sometimes it's a matter of a few inches, but sometimes it gets to be, we're talking 2 acres, a whole 40-acre parcel sometimes. And it turns out that if you occupy and use an area of property for long enough and treat it as your own property, the doctrine of adverse possession makes that your property by law. It's more complicated exactly how that applies, but that's the basic concept. Over time, property can become yours even if you don't have a deed that describes it. Adverse possession comes up most often for a typical property owner with a fence. That's really the classic example, and that has been for as long as we've had, real property and the law of adverse possession. Someone will construct a fence, and even if they get a survey to tell them exactly where the property line is, they might construct their fence a foot inside their property. They want to make sure they can stay on the other side, for example, or a foot on the other side. Sometimes it's a greater distance. And over time, they forget, or maybe they didn't know where the exact boundary was in the first place, and that fence might become the boundary by operation of adverse possession. Same thing goes with lines of trees and hedges, or even people might place a shed on a neighbor's property. And that's in a city lot. The same thing though can happen with pasturing cattle or with fences for cropland. When a client or a potential new client comes to me and they think they have a boundary dispute or maybe an adverse possession situation, to start, I think the easiest way to think about it is you have to ask the basic questions: the who, what, when, where, why, and how. The who is really important. Who are the parties involved? With adverse possession, it's not going to just be the current property owner necessarily. Do you have a governmental entity who owned that property 20 years ago? The what sort of property is involved? Is it hunting property, a city lot? Those are important things to know about property and deciding if you have adverse possession. When? Are we talking 20 years of adverse possession? Was it occupied between 1930, 1950? What time period? Where? How much property is involved? What is the actual boundary line that's in dispute? And why? There was a recent case in Wilcox versus the state of Hines that told us it was important why you were possessing the property. Did you intend to possess it? Was it with the permission of the true owner? Did you think it was your property? And then very importantly, how? What were your acts of possession that constitute adverse possession? When I have all that information, I sit down and I think, does this equal adverse possession? I compare it to the case law. And then I start to think about possible defenses and different related doctrines maybe that could come into play, such as the doctrine of acquiescence or easements. Attorneys should know that the statute isn't going to answer their question in most cases. You need to look at the entire body of law that has developed over time. The adverse possession statutes actually codify the common law. And so there are different elements even in the cases than ours are listed even in the statute. So the elements of adverse possession are continuous, exclusive, open and notorious, and hostile possession, whereas there is no reference of most of those terms in the statutes themselves. Attorneys also need to know that you shouldn't just look at either the first case or even the last case. It's been a long and complex doctrine that has evolved over time. And a good place to start is probably the latest case, but there are plenty of cases from over 100 years ago that I still reference and that are still relevant good law that you will need to be aware of. Part of why I wrote my article is sometimes it's really hard to find a good summary of adverse possession law. A lot of the treatises will have it, but that's on a nationwide basis. And our state, along with a lot of other states, has developed the law in its own way. So I think the best way to sort of follow along and know what you should be looking at is to just go through the cases. You're going to have to do your case law research. Hopefully my article will give you a good starting point. And from there, you just have to get into the topic.
So that's from an attorney's perspective, telling you about adverse possession and how it works and how they go about claiming it, and that it's not that easy. They got to do a lot of research. They got to know about the laws, the reasons, etc. So here's an example of criminals actually using the law, and some example of why a little bit of knowledge can be a dangerous thing. Stress there on little knowledge. When somebody thinks they know the law and they say, I know my rights, I know the law, but do they?
Nope.
A bit more headlines, but the young man moved into a $2.5 million mansion near Miami without paying a dime. We first told you about this story Friday morning, but we're now learning that this has become a national trend, and some of the people doing it are even connected to an anti-government group the FBI classifies as domestic terrorists. Boca Raton, one of the poshest zip codes in Florida, is abuzz this morning over what is happening inside this $2.5 million, 7,500 square foot waterside mansion. The bank foreclosed a couple of years ago, but now a 23-year-old named Andre Barbosa has simply moved in.
Nobody's happy. We all spent a lot of money to live on this too.
Barbosa is using an obscure legal concept on the books in every state called adverse possession, which says if you live in an empty home for a certain amount of time, it's yours. Adverse possession is being attempted all over America. Susan Weidman took over a series of homes in the Atlanta area.
I filed adverse possession back in February as Susan White, I think the Chad Courthouse. So I'm not just, transient squatter here.
This $3.3 million house near Raleigh, complete with an elevator, got caught up in this whole mess when Sean Pendergraft claimed he owned the house.
Out of town. Everything we're doing is lawful.
There have always been squatters, but the housing crisis has put the phenomenon on steroids. Some of the people using adverse possession are connected to a sometimes violent anti-government movement known as sovereign citizens. U.S. laws do not apply to them.
A police officer walks up to someone who is claiming a house now belongs to him without any basis at all, is handed a big sheaf of documents which are incomprehensible, and I think very often the officers ultimately feel that they're forced to go back to headquarters and try and figure out what's going on before they can actually toss someone in the slammer.
I met a young sovereign named Robert Peterson who moved into this foreclosed home in Idaho.
They're the enemy. They're the enemy of anybody who wants to live free.
One expert on sovereigns found evidence to suggest that Andre Barbosa, in that mansion in Boca Raton, is connected to a sovereign group called Divine Province, based on the language Barbosa used to justify moving into the mansion and the fact that his name is on the group's website. Before you get any ideas about trying to use adverse possession, consider that the sheriffs forced Robert Peterson out of this house, and remember Susan Weidman, arrested for racketeering, and Sean Pendergraft, also arrested for obtaining property by false pretense.
All the legal arguments he may make or the documents he may file will all end up leading to the same conclusion. And that is that he gets kicked out because he has no legal right to be there.
As for Andre Barbosa, he may be running out of time in that mansion in Boca. Bank of America has now filed a claim in court claiming it is the rightful owner of the home.
It's so crazy that they're arguing that the law's on their side.
They are in kind of 1/3 right.
Fascinating story. All right.
And it's true. They know a little bit about the law, but they don't know actually why that law is in place, and they're trying to take advantages of loopholes and such. And what's the craziest thing is I actually see online on the on YouTube, you could go out there and you could find plenty of examples on YouTube where you got people that are coaching you, telling you how to get rich in real estate, or how to get ownership of a house in real estate by using adverse possession or easements by prescription. I think they use adverse possession though as their terminology. How to get rich in real estate and how to gain ownership of real estate with no money through adverse possession. And it's like they're guiding people on how to break the law. And they'll sit there and argue with you online about it too. I've reported a lot of these videos to YouTube, but of course, YouTube, you'd figure, owned by Google, the kings of censorship, that they would try to prevent people from spreading falsities that it would take them, possibly put people in jail for. But nope, they're allowing those videos to stay on there. They say they don't violate their terms of service. I thought coaxing people to violate the law would be, but apparently, I guess it depends what that is. I think they care more passionately about elections and COVID, people's opinions on COVIDs and such, more than coaxing somebody how to violate the law in this regard, which is the wackiest thing. So don't go following any advice that you see on online on YouTube or whatever pertaining to that, because it just may land you in jail.
A bit more bizarre.
Here's another example, another case of this.
Now a warning about the risks more and more people are taking to get a house for next to nothing. It's an obscure law some hope to cash in on, but often land in jail instead. Our Chris Trankman joins us live in Polk County to explain more on this. Chris?
Well, the sheriff says some people never learn. This is the house in question. It's valued at $160,000. It's in foreclosure, and both deputies and residents here are baffled why a couple thought by breaking in, turning on the power, water, and cable, they would have the right to own the house without paying for it.
With the homes being vacant, it just takes neighbors in the neighborhood having their eyes and ears open.
Danny Rodriguez says residents along Echo Lane noticed a locksmith changing the locks and moving trucks unloading furniture into this vacant house. As the Homeowners Association president, familiar with his neighbors, Rodriguez suspected a scam.
I knew a little bit about adverse possession just from doing some research saying you need to be in the home for 7 years. And I noticed they weren't here for 7 years.
Adverse possession is a Florida law from the 1800s that applies to unoccupied farmland. The property appraiser alerted sheriff's deputies about Sherry Fields and her husband after they filed for the obscure law. They were charged with burglary and grand theft. Meanwhile, Sherry Fields is a teacher at Ford Meade High School.
Come on, girl. You know, you got a college education. You should know better than that. But anyway, we gave her a field trip to the county jail.
Sheriff Brady Judd says more people are learning about adverse possession from websites online, mistakenly thinking they can use the law to take over an unoccupied house for free.
Of course, we all know if it's on the internet, it's got to be true. Well, what they didn't see on the internet was my Facebook page that says, "We will put you in jail."
You know, we work hard for our homes and what we have, and it's not fair for someone to just come in and take somebody's possession like that.
And the sheriff says the school teacher and her husband are going on another field trip, this time for a crash course on Florida law. They'll be in a courtroom tomorrow. We're live in Polk County, Chris Trankman, ABC Action News.
Yeah, it's the nuttiest thing. People see stuff online. It's got to be true. That sheriff is great. Sheriff Grady. You guys probably saw him on the news for a lot of things. He's a sheriff in one of those big counties in Florida. You always see him on the news for something or another. That guy's a trip.
Now a warning about
All right. Here's another one on adverse possession.
Caught in the act, how one woman stopped a group of squatters from moving into a vacant home she owns. Good evening, I'm Jackie Parks.
And I'm Todd Carley, 23 ABC's Mark Christian is live tonight from a home in Oildale where those squatters were trying to take up residence. Mark?
Okay, before he starts giving this report, this is in California. California's got some really wacky liberal laws that are for protections meant for tenants, though. New Jersey, though, we're a very blue state as well, and we usually often follow the direction that California goes in when they pass laws and regulations. So something to look out for. You know, we are in New Jersey a tenant right state as well. But the only problem with that is if you're not a vigilant property owner, you could get screwed in the process. This is an example where the tenant's rights could supersede the rights of a property owner. And you get these scammers that go out there and they learn a little bit about the law and they try to take advantage of it. They move into your house and then you have trouble getting them out.
Well, guys, if you think of someone who's living in a home illegally, it'd be a simple case to get them out. Well, squatters move under the radar to try to move in very fast, and in some cases even changing the lock so they can move in before the owner finds out.
I saw like about 20 people at my property trying to move in as fast as they could.
After her previous tenant moved out, the home had only been vacant for 10 days. Unfortunately, some of these squatters have gotten pretty sophisticated. Rena Chanty was getting her home ready to put it up for rent when a neighbor called to tell her someone was trying to move in. The squatters were moving in a refrigerator, a washer and dryer.
Basically everything a house needs. They were decoration pieces. And they had changed the locks.
When deputies arrived, the squatters were still in the process of moving in. Though not commenting on this specific case, Ray Pruitt with the Sheriff Department says the squatters can take refuge under the California tenant law and have even been known to falsify rental agreements.
Once they're in that property, in some cases, it's very hard to get them out of that property without
legally evicting them. In cases like this, law enforcement's hands are tied because if the squatter presents what appears to be a legal agreement, it comes down to he said, she said.
Sometimes we can't determine if the squatter's in the home legally or not.
They know the system and they know how to play the system.
Fortunately for Chandy, the squatters did not get that far and could not provide any documents to law enforcement.
At that moment, the cops told me it was my word against their word, and I had to prove that I owned the property, which I had the paperwork on me.
So right now, Chandy is checking her house daily until she can officially get it rented. In the meantime, she's asking her neighbors to keep a watchful eye until that place gets rented. Back to you, Jackie.
It's the craziest thing that people that would do, some of these criminals are pretty smart though, but if they would use half of that effort towards like positive things, positive steps to get a job or do things positive in life, they may actually be successful people. It's amazing that they, they rather do things like that to violate the law. Anyway, party walls. Party wall is a shared common wall between attached housing or a wall that separates two properties, like with townhouses, right? Or condo units. It's that shared common party wall that separates those two units from each other. And without that wall, there would be no separation. So usually there's some sort of a party wall agreement that each party is responsible for maintaining their own side of the wall. So let's highlight on page 111, a party wall is a wall of a building that straddles the boundary lines between two owners' lots. And then we already got the license down. We highlighted this already on page 112. License can be revoked at any time. It's permission to enter the land of another for a specific purpose. Whereas an easement is a right to enter the land of another for a specific purpose. So we got the party wall agreement. That's that shared common wall that separates two properties. License, permission to enter the land of another. Easement, a right to enter the land. And an encroachment. Encroachment is anything that crosses over the property line, as when a part of a building, fence, or driveway, or any other installation illegally extends beyond the land of its owner onto the neighboring property. That's what an encroachment is. They're encroaching in your territory. I had a student give me this clever definition one time. An encroachment has the word roach in it. So much like the word roach, it's something you don't want on your property. But it's extending from the neighbor's property. The neighbor builds the shed or the garage over the property line or something along that nature. Well, that's an encroachment. It's illegally extending onto your property line. If you're buying a property, you should really want to make sure that there are no encroachments onto your property from the neighboring property, because otherwise you're buying a house, you're buying a property that's you're buying into a problematic issue already. So this is why we do another type of home inspection when we buy properties, and that inspection is called a survey. Right? So a survey is an actual measurement of the land. It makes sure that the neighboring property isn't extending onto yours. Wouldn't you want to know if they built a garage over the property line or a shed over the property line? Or to know that the fence is actually on the property line and not on your property? That could be important, because that means that the neighbors are using your property if they got their fence over on your property line, right?
Right.
this was actually an issue with me recently. I had a neighbor giving me all kinds of crap. They actually got a city inspector. They were trying to, the city inspector even gave me a ticket, to appear in court. I couldn't even, just, question it. I had to go to court over this, over a problem, an issue. There was, some tree branches that fell from my neighbor's property onto my property. And, they fall to the property, and sometimes they throw it over the fence. And I know it's their branches because I don't have a tree in my backyard anymore, so it's coming from their trees. So I just take those branches, and I've been piling up on their against their fence in the corner of the property by the where I put the lawn clippings, you know. And I got a summons in the mail from the like a day or two after my rear neighbor's wife came to my house and telling me that they're planning on putting up a fence on their property, a new fence, because their fence was old and it was starting to fall down. It was leaning over. So they were telling me that they were we're not going to have a fence for a couple of days separating the properties as they put it up, as they took down the other one and put that one up. I was like, okay, yeah, no problem. Never said anything else. Next thing you know, 2 days later, I get a summons in the mail from the city inspector because her husband had the city inspector issue me a summons for having garbage in my yard, the branches against the fence, you know. And I was like, what a scumbag. You know, he couldn't have just asked me to remove it because he was going to be putting a fence up over there, you know. So anyway, I got rid of all that stuff, called the inspector. He's still required to go into court over it, being a ball buster. But probably because I, with his summons, I called up and I asked him, I was like, what garbage? What are you talking about? I don't got no garbage in my yard. And they're like, oh, there's a bunch of branches and stuff piled against the fence. I'm like, oh yeah, that's from that neighbor. You know, I was like, well, how did you find out about that, first of all? Because you can't see that from the street. And he's like, oh, your neighbor, they invited me onto their property and I seen it from there. I was like, you can't see that from my neighbor's property. And I was like, there's a 6-foot fence over there. There's no way for you to see that on my property. And he's like, oh, well, I took my camera and I reached it over the fence and I took a picture. And I was like, you did what? Who gave you permission to do that? He's like, oh, I could do that. He gave me permission to be on his property. I was like, I don't care what the neighbor gave you permission to be on his property. If you can't see it with your normal eye and you have to use other means to try to see something on my property, that's a violation of my Fourth Amendment right, illegal search and seizure. You know, you can't take pictures. Oh, I could do whatever I want. I could take pictures. I was like, all right, see you in court. You know, and I was like, it was amazing because he took the camera, put it over the fence so he could snap pictures to see it. Or at least that's what his claim was, to better see it. They went as far as even kicking out a couple slats in the fence so that he could stick it through the fence and take pictures in my yard and try saying, oh, you got to clean this up. You got to clean that up. And I was like, no. I was like, you can't see any of this stuff from the street or from one of my neighbor's properties. Therefore, you can't hold it against me, you know. So I made a whole big deal about it. And then I wrote a letter to my neighbor to tell him what a jerk off they are. And I took pictures of and the thing is, I recently had a survey done on my property, and I found that his fence was actually almost 2 feet on my property. So I made us think about it. I said, yeah, you're putting up a new fence. Make sure it's on your property line, or I'm going to make sure it gets removed, because I will take you to court and sue you over it. If you want to be a jerk off, I could be a jerk off too. You're putting up a new fence. Make sure it's on your property this time, you know. And I just stuck it to him in that letter a bit. And I sent him a copy of the survey that shows the same thing. Next thing you know, he's got a long delay in getting his fence up. He's getting a surveyor to come out there. He had to now pay for a survey to get done to make sure the fence is not just getting put where the other one was, and they had to put it back. So I cost him a couple $100 for him being a jerk like that. Who cares? It's his problem, right? Shouldn't have been a jerk. Anyway, a survey is a measurement of the property's boundaries. I'll show you a picture.
We can't see your screen.
What's that?
I said we can't see your screen.
You can't see my screen. Do you see me?
Are you sharing?
Yeah, we see you.
Yeah,
We
that's
don't
all
see
you,
what you're
yeah, that's all you should be seeing right now is just me.
Oh, okay, okay.
I'm not sharing anything yet, okay? So I will in a second. I'm gonna pull up, I'm looking at another screen myself, trying to get to and show you a copy of the pictures of the survey and this guy's fence and everything. Just give you an example of why you would need to get a survey done. Surveys are important. Surveys will tell you whose property is where your property's boundary lines are. It's impossible for you to be able to tell where a property's boundaries are simply by looking at a fence. How do you know the fence was put in the right place, right? And when we show people houses to buy houses, sometimes they look at them and they're like, oh, where's the property line? They ask us. Or they're like, is it where the tree, is it where the bushes are, or is it where that fence is over there, or is it where the property kind of like dips down a little bit like that between the properties? It's impossible to tell. You can't tell by contours in the ground or where bushes are. The only way to tell where a property line is by a competent surveyor. You know, trees, property lines can run through a tree. You know, a tree can be half on one person's property and half on another person's property. The only way to know is to get a survey done by a competent surveyor. That's the only way to know. And let me see, I'm trying to pull up my survey and what happened here on my neighbor's property here so that I can share that with you. Here we go. I'll show you some pictures, then I'll show you the survey. Show you the pictures where he put up the new fence. And that new fence, you could clearly see he now set it back to onto his property a little bit further to where it actually belongs. But the interesting thing is these there are certain setbacks. And in my town, the property has to be 3 feet. Any fence, if you're going to have like a shed on your property, has to be at least 3 feet off the property line. And how this guy, he's got a fence, or he's got a shed, and now that he set that fence back where it actually belongs, it looks like his shed is actually less than that 3 feet from the property line. Now, if I want to in the future, if he's ever a jerk to me again, I can make us think about that to the city inspector. But take a look. This is his shed. Look how close it is to the property line there now. All right. Now you can't really tell from this standpoint here, but let's see. See, I started making a point here because I was thinking about making a stink about it. And all the crap, I took a picture over his yard, into his yard. Look at all the crap he's got in his yard. He's making a stink about my clean yard. Get out of here. And then his fence does this. Look at this. He actually cut it over a tree. That tree is partially on the neighbor's property, partially on his property. All right. Let me pull up now where is it? We get a better view of this. Oh, let's see, I gotta open it up again in a different way. So here's a picture of the survey that I got for my property. And I highlighted some differences here that show actually that the neighbor's fence was intruding on my property line back there. Let's take a look. There you go. I highlighted it. It was 1.4 feet. Okay, so almost 1.5 feet. Not even 2 feet, 1.5 feet on my property line. But it was the whole length of the property. that it was over the property line there. And so I made a big stink about it. What the hell? You're gonna get me a summons from the city? Why not? And I'll show you what it was over, you know. Let me see. So here they kicked out a couple of slats out of the fence to take a picture into my yard. Here's where I had that wood pile. I pulled it out. That's the garbage I have in my yard. I'm emptying my shed to build a new one. You can't see anything there from the street or from the neighbor's property. My yard is clean by comparison to his. Look at this. Look how far off the property line. Yeah, he got his own survey markers now in there. And you could see how far off the property line his fence actually was, because his previous fence came right up to here. So that's how far he was off on the property line. See the whole length down? Look at that.
So you gained a little bit?
Yeah, I gained a little bit. He had his fence on my property. You could see the difference in the cutaway in the dirt here, right?
Yeah.
Yeah.
So surveys matter, you know, it's important to get a survey so you could see that, know where your property line is. So his fence was encroaching onto my property. Got it removed.
How does the survey know the property line?
Well, the surveyor will come out and they'll do measurements. They'll do measurements as reference of like, how do we know where our country's boundary is? How do we know where our city ends and the next city begins? It's all by surveys and surveyors that have done, they measured out the land over the ages as we formed as a country. You know, that's how do we know the difference where the Canadian, US property line is or the Mexico US property line is. There's been surveys done. You know, at one point it was done by people who actually walked the land and measured it out. These days they use tools that allow them to be a little farther apart and still take those measurements. But there's various tools. We'll get over them in chapter 19 when we talk about how they do surveys and such. But these surveys have got to periodically be done. Anytime you transfer ownership, people usually pay for a survey to get done. You want to confirm, because it's one thing, I could give you a survey map. It's one thing to have a survey. It's another thing to be able to actually, if I gave you a survey and I say, okay, show me where your property line is now. Let's walk up to the property and show me where your property line is. It's not so easy to do. So you got to pay a surveyor an additional fee to actually bang stakes into the ground, wooden stakes or metal stakes into the ground that will show you where you can now visualize where the actual property line is. So surveyors usually can locate previous metal stakes that are put in the ground with metal detectors. They know where they should be. They put the metal detectors in the ground, or they take their measurements and they know it's somewhere around there. And usually they could dig it up and just pull it up out of the ground a little bit so you could see where the property line is, you know. But you're going to pay an additional fee for a surveyor to bang stakes into the ground at each of the corners of the property. Okay. And that fee can vary greatly. So you really should shop around with surveyors. But our job as real estate agents is to make sure that the property buyer, when they get a survey done, because they will get a survey done, they have to, it's important that we guide them and tell them that they should pay the extra fee at that time for the surveyor to put those stakes at the corners of their lot. So now you could tie a string around one to the other and you could visually see where your property line is. Okay. See, on my survey that I showed you, it actually showed you where the structures were and that the neighbor's fence was how far over on my property, you know, which was a great help for me when I was gonna complain to him about it. All right. So his fence encroached onto my land. That's what an encroachment is. A perfect example right there. Now, how do you create an easement? An easement is a right to cross over one's land onto another. So how do you create an easement? Well, here's the bulleted list in the book on creating an easement. I just copied it here in my own words a little bit. By express grant of permission of the property owner. by a deed conveying or creating an easement over the sold land. Granting the new owner an easement over the grantor's remaining land. The grantor is the seller, remember? The long-time usage via an easement by prescription. However, this is a type of easement that is gained only when you're using someone else's property for a limited period of time or for amount of time as required by law. And then it has to be perfected with a court action. And that's how you gain ownership of somebody else's property if you've used it for a long enough period of time. So what kind of easement do you get through using someone's property? An easement by prescription, also known as adverse possession. By necessity. An easement by necessity is an easement that's used to gain access for the purpose of ingress or egress to cross over someone else's land to get to yours when your land has been landlocked. So it's necessary to cross over your neighbor's property to get to yours. That's what an easement by necessity is. Yeah, you guys have to understand and know the different types of easements and what their purposes are. You know, by an easement in gross, that's a public or utility easement. This is the only type of easement that will go away if it's no longer needed. Now, if you don't have an easement and a public utility wants to create an easement on your property now, well, they're going to have to pay you for the usage. They have to justly compensate you for that usage of your land too. But check this out. I could show you a survey of pictures on my property. I'm not going to do that right now, but I have a surveyor pictures where the surveyor's markers actually appear to be about 6 feet off the curb, from the curb onto my property. That's where the first surveyor marker comes. But my corner of the property goes all the way out to the curb. Why do they do that? Well, did you know that the first 6 feet of your property, your city has an easement right to it? So if they want to put a telephone pole or plant a tree in front of your house, they could do that if they wanted to. If they wanted to put a sidewalk in, they could do that. And then who's responsible for maintaining the sidewalk? Making sure it's snow shoveled. You are. But if it breaks up, don't go fixing it. Call the city, because if you do a repair that's wrong, you could end up getting sued on that. All right. How do you terminate an easement? Well, when the purpose for the easement no longer exists. That only applies to a easement in gross. Or when the owner of the dominant estate becomes, the owner of the dominant or servient tenement becomes the owner of the other. You don't need an easement to cross over your own property. So if you bought your neighbor's property that had that easement to cross onto yours, no more easement. You don't need an easement to cross over your own land. The dominant estate can also release their easement right. They could give up their easement right to the servient estate whose land is being crossed over. Or by abandonment. But this one, take it with a grain of salt. It's hard to prove that somebody abandoned their property, even if they haven't been there for ages. Courts have determined that simple non-use does not constitute abandonment. You have to prove it was the person's intention to abandon the property and never come back or use it again. All right, so if you didn't highlight it already, page 112, highlight encroachment. When all or part of a building, fence, or driveway, or any other illegal installation illegally extends beyond the land of its owner. That's an encroachment. And then deed restrictions, also known as restrictive covenants. These are those restrictions placed in deeds. When you have an estate in land called fee determinable, defeasible, or conditional fee estate, that's the type of estate in land that's based on a condition. As long as that condition or restrictive condition does not get abused or broken, you remain the owner. but there's always that possibility of reverter that if you do break it, you could lose the ownership, right? So what kind of, let's see, what do we call restrictions placed in deeds? We call them restrictive covenants. So next to deed restrictions, right, restrictive covenants, those are the restrictions that are placed in deeds. And what kind of estate and land has restrictions on it? Well, on page 104, that's where we went over that earlier in this chapter. It's called fee determinable, defeasible, or conditional fee estate. You could either write that all down or just write see page 104. But fee determinable, defeasible fee, conditional fee. So deed restrictions are restrictive clauses added to a deed when a property is conveyed that are established by the seller to restrict the future owner's use of the property in some way, shape, or form. Let me know when you guys got all those notes. Then we'll be done with this chapter and we'll do the key terms. What's that?
One second.
Yeah. Just let me know when you're done.
R. Oh, I'm good.
You good? Is everybody good?
Yeah. Covenant.
Yep.
Okay. And that's
Lord,
it
this
for
is a
this
lot of terms.
chapter. So let's do the key terms to review now. And before we get started in the key terms to review, under key terms 1 on page 114, next to letter A, cross out the word indefinitely and write forever or a lifetime. Next to letter A in key terms 1, cross out the word indefinitely and write forever or a lifetime. Yeah, it also pays to have some of that whiteout tape. You could make corrections really quick and don't got to wait for it to dry. If that's what those sounds are over.
No, the sound was just because there's so many terms.
Ah, yeah. Well, you're learning a new language in 75 hours. Remember that.
Right. Oh, wait a minute.
All right, go to the letter E. And at the end of where it says ownership as long as, write based on a restriction. Based on a restriction. Based on a restriction.
What do we cross out for that?
You're not crossing out anything. You're just writing after where it says ownership as long as, you're writing based on a restriction. Try to keep it to one line though, because right underneath it, the very next one, F, you're going to cross out something and write something right next to that one as well. So try not to use up all that space if you can. So right after letter E, ownership as long as, you're going to write based on a restriction. So it's ownership based on a restriction. Or they have the words as long as you don't violate this restriction, you remain the owner.
Oh, man.
Oh, man.
Yeah, I'm not retaining the other stuff that we were doing. I was like retaining it like right away.
Well, right now you just take your notes. You'll retain it later when you study them. Maybe put them in flashcards or those digital flashcards that you could get from the apps on what's that, Quizlet. You could have the flashcards for studying these terms and definitions. But other than terms and definitions, we also had some concepts today. Like the types of estates and a life estate por otra vida, for the life of another. Well, that's one's not really a concept, that's a term. But the concepts you need to understand for life estate, the different types of estates in land. What's the highest form of ownership recognized by law? Fee simple absolute. What's a type of ownership based on a restriction? Fee determinable, defeasible, or conditional fee. And what is the type of estate and land that's based on someone's life? A life estate. And a life estate that's based on someone else's life, a life estate por otra vida.
Por otra vida.
Por otra vida. For the life of another. So next to letter F, you're going to cross out, well, I guess it says amount of ownership. I guess you can cross out of ownership. And you can have amount or kind of interest in real property. Amount or kind of interest in real property or realty.
Can you say what's after interest?
You could write of real property or of real estate or realty.
So that would be amount of kind or
amount or kind of interest in real property.
Oh, for it. Does it matter if it's for in?
Well, it's your interest in that real estate. So as long as you understand it, it's all that matters. And then in key terms number 2, next to letter D, it says notice that a lien may be filed. Cross out the word lien there.
Which one is this?
And write legal action, D, in key terms 2.
Oh, key terms 2.
Yeah, cross out the word lien and write legal action. So a notice that a legal action may be filed. That's what that should be. Then go down to letter J. And where it says third party who will gain eventual ownership, cross out the word will and write may above it. Third party who may gain eventual ownership. And then next to letter L, this is the last one. Next to letter L, well, towards the front of the line where it says future, just right above the word future, possible. So possible future interest of an owner. So you're just writing the word possible there above the word future. Possible future interest of an owner.
I missed those, Victor.
What'd you miss?
On terms 2, you said I missed the first one was
D was legal action. So next to letter D, you crossed out the word lien and you wrote
lien.
legal action.
Okay, legal action. Okay, and the other one?
J, next to letter J, you
Uh-huh.
crossed out the word will and you wrote may.
Crossed out what?
The word
Crossed
will.
out. Excuse
Where
me.
it says who
Okay.
will gain eventual ownership, so that it
May.
reads who may gain eventual ownership.
All right, and you said L too?
And then L at the front of the line, you're writing the word possible above future. So it reads possible future interest of an owner. Okay. So now let's do those key terms, shall we? Ownership lasting forever or a lifetime. Ownership lasting forever or a lifetime.
Ownership.
Ownership lasting forever.
Estate and land?
Or a lifetime is a freehold estate. They're talking about the category of ownership. That would be a freehold estate. Ownership lasting forever or a lifetime. That would be a freehold estate. 16 is A. A permanent right to use another's land.
Dominant estate?
No, what do we call the right? A permanent right to use another's land.
Estate and land?
An estate in land describes the amount or kind of interest that one has in real property. But a permanent right to use another's land. Let's see, you have a right or permission. What do we call a right to use another's land?
I don't remember.
Well, it's not just you. I'm asking everybody here.
I know. I don't remember.
It's an easement.
Easement.
An easement is a right. A right to use someone's land for a particular purpose is an easement. 6 is B.
Wait a minute.
6 is B.
6 is B.
Husband's right to use the wife's right, or the husband's right in the wife's property.
Courtesy.
A husband's right in the wife's property is courtesy. 3 is C. Because men should be courteous to women, right? A right that runs with the land. What do we call a right that runs with the land? Now, it's basically any easement, but there's a particular easement that has that in its definition, that it runs with the land. Remember, when it came to easements, there's 2 categories.
No.
Which one runs with the land? Even though
Necessity?
technically they all do, but
Necessity?
an easement appurtenant. They could be, easements can be appurtenant or engross. If it's not an engross is a utility easement. All other easements are basically appurtenant.
Oh, appurtenant. Okay, yeah. Okay.
Appurtenant.
Appurtenant.
7 is D. That means there's a dominant estate, there's a servient estate, adjacent parcels of land. And that easement, once it's created, it runs with the land. So that it specifically says that in its definition. So that's the way they got it worded here.
Adjacent parcel of land.
7 is D?
7 is D, correct. D. 7 is D.
Right to
An
revoke.
easement, pertinent. And ownership as long as, or ownership that is based on a restriction. And as long as you don't violate that restriction, you remain the owner. What do we call that ownership that's based on a restriction? The one that says you're the owner as long as but you can't use the property as a gas station. So as long as you don't use it as a gas station, you remain the owner. But if you
The
violate that,
Estate and land.
easement of land?
what kind of estate in land? Ownership as long as, or ownership based on a restriction. They're looking at a type of estate in land.
That's 13?
A type of estate in land would be, no, we're looking for the fee determinable. Remember, an estate in land describes the amount or kind of interest one has in real property, but there's 3 types of estates in land. Fee, which also is known as fee simple, or fee simple absolute. Fee determinable, which is also known as a conditional fee or defeasible fee. And then we have a life estate. So the conditional fee or defeasible fee or fee determinable is the one that's based on a restriction. So 14 is E.
Yeah, I need to study this one.
Yeah, once all the terms and definitions, we start getting
This is
into
not
real estate, the
clicking.
terms and definitions, you just write them down and then you can study them later. You know, don't get all frustrated now. Just get it and understand it when I explain it to you. And then later on, you could just refresh your memory by studying it up. That's why I say
No,
during the
that's
class, just take your notes and write your definitions. And then after class, decompress for an hour or two, whatever. Then maybe sometime take like 30 minutes to rewrite all your notes or your highlights so that you could, or if you only wrote them in the book, to copy them over onto like a notebook or something where you'll study it from.
No, what I'm saying is like sometimes like since the stuff that we've been doing, some of it's clicking for my recall to call it back to even do these questions.
Yeah.
This is not like clicking for me like that.
So it requires a little more study. That's all right. It's all right. I'm not expecting you to get it all right now immediately, but you got to review the stuff to study it. You know, I crammed for it when I was taking mine and when I went to school, as long as it was explained to you initially so that you understood it and you got it.
Right.
You write it in your notes and you could just study it over and over and over again until you learn these words, you know. And one good way to study it is not just by reading it over and over, but to actually copy your notes, to transpose your notes, the things you highlighted or notes that you've written in the book. Try to write them all in a notebook, because now as you're reading it, you're thinking it, and now you're rewriting it and thinking it again. And so your mind will absorb it a lot better if you do it this way. All right, so what was the last one we just did? 14 was E.
I don't know.
Amount or kind of interest in real property. That's a definition of something that I just spoke about. An amount or kind of interest in real property is described as. What'd you say?
Isn't it estate and land?
It's an estate and land, correct. 13 is F. The right used for utility lines on another's land.
Easement and gross.
10 is G.
Got one.
A right of access to a landlocked parcel.
Landlocked parcel.
If you own land that's landlocked, how do you get to it and get off of it?
Easement by necessity.
It's necessary to cross over another's property. Easement by necessity. So that is 8 is H. A wife's right in the husband's property. What do we call it?
Dower. Dower.
5 is I. A right sometimes acquired through usage. When you use somebody's property for a period of time as defined by law, Well, you could possibly gain this right. Right?
Easement and prescription.
Easement by prescription, 9 is J. Transfer by sale or gift is known as another word that means transfer.
Convey.
To convey. 2 is K. Property that benefits from an easement. Who benefits from an easement?
The person who's getting the gift.
Yeah, but who's benefiting from that easement? What do you call that? What do you call that estate?
Dominant estate.
The dominant estate benefits from the easement. 4 is L. Most complete ownership of land possible. The most complete ownership forever without restrictions. Let's put it that way. The highest form of ownership recognized by law.
No. Fee
Is it
simple?
12?
It's fee simple,
Fee simple?
fee simple absolute, it's known as, yes. Fee simple, or fee simple absolute. 15 is M.
Huh?
15 is M, as in Michael.
Oh, it is fee simple. Okay, great.
Yes, but it goes by 3 names. You could just say the word fee simple, or fee simple absolute describes the same estate. It goes by those 3 names. Any easement, encroachment, etc. They're all an example of an
encumbrance.
Yes. 12 is N, as in Nancy. Placed against real estate by a worker who has not been paid.
Construction lien.
A construction lien. What is a construction lien also known as?
Lien. Mechanical lien.
A mechanics lien. A mechanics
lien.
Yeah.
Okay.
So 1 is O, construction lien. I just asked you the question, what is it also known as? Mechanics lien. 1 is O. A building intruding on another's land.
Encroachment.
An encroachment. 11 is P. Now let's do key terms 2. Key terms 2. A structure owned by 2 adjoining landowners.
Severance estate.
What do we call a structure that separates 2 properties?
Party wall.
A party wall. 9 is A. A claim against all property someone owns.
Lien.
Kind of lien.
Hmm?
What kind of lien affects all the property that someone owns?
General lien.
A general lien. 1 is B. A claim against 1 parcel of real estate. Only 1 parcel of real estate. Not all of it, but 1 parcel.
A lien.
What kind of lien?
I wanted to just be the regular lien.
Well, a lien is a financial claim on property. The last one we did was a type of claim that covers all property that someone owns. That was a general lien. 1 was B. And what kind of claim
mortgage lien
is against only 1 parcel?
Mortgage lien.
Even though a mortgage lien only covers 1 parcel of land, you're being specific. You're being specific because that's a voluntary type of lien. There's other types of liens that cover only 1 parcel. So they're looking specifically for, what do we call any kind of lien that only covers 1 parcel of land?
Specific.
It's specific. 14 is C. A notice that a legal action may be filed. A public notice of possible future legal action.
I know this one, but
7.
less depends.
Lis pendens. A lis
Lis pendens.
Lis pendens.
Okay.
7 is D. Lender's claim against real estate. Now,
Lien.
no. Mortgage lien. Now, that's the lender's claim. 8 is
Lien,
E.
mortgage lien.
Yeah, 8 is E.
Oh, okay. I was like,
A temporary permission. You also get one of these to drive.
license.
A license. 4 is F. A right to use and possess for a limited time.
Right to use and possess.
What gives you the right to use and possess someone's property for a limited period of time? Close your eyes. Don't even look at the list. Think of it. What gives you the right to use and possess someone's property for a limited period of time?
Tacking.
Close your eyes and think for a second. Don't look at the list.
I'm not looking at that.
Close your eyes. What do we call a right that's given to you to use and possess someone else's property for a limited period of time?
I need to look at the words.
No, you don't. No, you don't. Think of it for a second. What gives you the right to live in my house?
Would it be like a contract or a deed?
Well, hold on. What would we call that contract? Deed is how you transfer ownership. I'm not giving you ownership. I'm giving you the right to live in my property for a limited period of time.
It's a lease.
A lease. A lease. That's it.
Oh,
It's a lease.
it's a lease.
Now it makes sense. Now
You guys are overthinking this stuff. You're overthinking it. That's why I said at some point, just stop looking at the answers, because some of these you could get if you just think it out for a second, what I'm asking of you, you could figure it out. So which letter was that?
I don't see that. I don't see a lease on here.
A right to use and possess for a limited period of time. Well, 3 is G. That's a leasehold estate. You're leasing the property.
Oh, okay.
It's a leasehold estate. So 3 is G. And I told you,
Right.
look.
Because I was like, that's not
I
there.
told you not to look. I told
No,
you.
but you told me not to look. We didn't. I closed my eyes,
It's a lease, right? And
but then when I went back, I was like, there's no lease. It's leasehold estate.
Well, it's a leasehold estate. It's a leasehold estate. 3 is G. A property taxes are one. Property taxes are one example of this.
Involuntary lien.
It is. 2 is H. The order in which liens are repaid or paid.
Priority.
Yeah, they're paid back according to their priority. 10 is I. And what determines the priority of liens? It's not on this list.
Who filed
The
first?
deed of recording in the public record, with the exception of 2 things: taxes and
Oh, shoot.
which one's retroactive back to the date that the work was
The mechanic, the construction
mechanics
lien.
lien, the construction lien. All right. So 10 was I. Third party who may gain eventual ownership.
Remainder man.
11 is J. Remainder man. The tract over which an easement runs. What do we call that tract of land over which an easement runs? That land that you're going to be walking over and using.
I don't know. Tacking? No, it's not tacking.
When you got to cross over someone else's property to get to yours, that's an easement by necessity, right? So what do you call that person's property that you got to walk over to get to yours? What kind of estate do they have?
13.
They got what?
Servient estate.
Servient estate. They're the servant.
Estate.
They're serving their property up on a platter for you to cross over and use. So 13 is K. Possible future interest of an owner.
Life estate?
Life estate.
If I sell you my property, with a condition that you don't violate the terms of the sale. If you do violate the terms of the sale, the ownership comes back to me.
Revisionary interest.
It's called a reversionary interest. And the same goes for a life estate. Life estate has a reversionary interest too. When the person who was given the life estate dies, the property reverts back to the person who gave it to them. Or a third party. And who's that third party? What do we call them?
Remainder man?
A remainder man, correct. So let's see. So 12 is L, the reversionary interest. Adding successive periods of usage. What do we call that?
Tacking.
Tacking. You tack on one person's time to that of the other. 15 is M, as in Mary. A complete ownership until someone's death.
Life estate.
6 is N, as in
Life
life estate. Financial claim against real estate.
Lien.
A lien. 5 is O. Didn't give you enough information to tell you what kind of lien, just the fact that it's a lien. Mortgage or equity loan, for example.
Voluntary lien.
Yeah, you went out of your way to get those, to create them, so they're voluntary. 16 is P, as in Paul. And that concludes the key terms for chapter 6.